Assalamualaikum and good afternoon, students.
Waalaikumsalam, Madam.
Good afternoon, Tata.
So for today's class, we'll be continue term and condition of employment. Okay, so this topic will be tested for quiz. Okay, so we will give you the most probably because of COVID now. I'm not sure the meeting on this Sunday will be going on or not. Okay, if not, we can release the assignment question to the students. Okay, but I think it's better for the student to concentrate on the mid exam first. Okay, then you can distribute your work among the group for assignment 1 and 2. Okay, so assignment 1 and 2 will be released I think most probably at the same time. Okay, but the date to submit might be different. Okay, so I'm not sure we can release both at the same time or not, but the submission date will be different. Okay, so you concentrate on the mid exam. Okay, then we'll give you the assignment questions. Okay, and at the same time you will have the quiz also. Okay, so when's your semester break? Students, when's your semester break? Is it after Deepavali? Any idea? Semester break leave do you have? Or 27? Oh, 27. Okay. That means after Deepavali, yeah? Okay. Okay, so I think we can start the class, okay?
Madam,
Yeah?
about the midterm exam, right?
Yeah?
Is it means that from morning until night we can submit it anytime we want?
Our time is we change
8 a.m. to 11 p.m.
Yes, 8 to 11. Okay, so you got 3 hours to open the question, answer the question, and PDF. Do it in PDF and send to the portal. Okay, it's all in is 3 hours. So it's up to you whether you can answer within 1 hour or 2 hours. Okay, but you have 3 hours. Okay, but make sure you submit within the time, that means before 11 p.m.
Okay, Madam.
So you do not open at 9 or in case you got any internet problem. So make sure that your computer is ready. Maybe you want the textbook to be with you, or maybe the statute to be with you. So make sure you have everything with you. Okay. But do not copy paste. Okay, you cannot copy paste if in case we detect. Okay. It will be the same rule for the final exam also. Okay. I think there will be one form for the student to sign before they take. If it is less favorable, then it is void to that extent. Okay. Let's say you are given annual leave. 2 weeks once. Let's say 2 weeks one. You cannot get every week. Okay. The employer says that every 2 weeks you only you are entitled for not annual leave. Let's say rest day. Because rest day you should get from the employer every week. So he said that only I will give you rest day 2 weeks once. Okay, so that term is actually what? Okay, so the other term will be valid. Okay, then it must be in writing. So the employment contract must be in writing. Okay, then it must have what you call the way the contract will be terminated. Okay, so I'm not going through all. I think I already completed wages. Okay, what is wages or what is salary? Okay. I'm not sure where I stop. Maybe the one attending to partner. Okay.
Madam, you stop at the wages deduction.
Wages deduction. Okay. payment done. Okay. Because it's very small. Okay. So no mind. I just reverse back. Okay. So section 22 is where once the employer give you the salary. Okay. It cannot be a full salary. Okay, because he is entitled to deduct. Okay. Salary. Okay. Which is under the law. Okay. First is where he is entitled to deduct. Okay. You don't mind? Okay. So he will deduct whatever necessary under the law like EPF, SOCSO and others. Okay. And he also will deduct whatever advances he give to you. Okay. So the advances can be for this purpose. And let's say you want to buy want to buy land or want to buy motor car or whatever. Okay. I think Amirul, please Salmizu Azwan, can you off your mic? Can you mute? It's unmute, no? Okay. Salmizu Azwan, because we can hear a lot of noise. Okay. Okay. So advances already complete. Okay. So then let's say you got a case that you have to attend at the court. No? So the employer also can he's entitled not to pay. Okay, because the employee is not entitled to any wages for the time that he spent in the prison or maybe traveling to and from the prison or going to the court, except the employee goes to the court for the employer's purpose. Okay, then here is the deduction. Um, um, Deduction, I think I already mentioned to you. The employer can deduct, okay, any money that he paid by mistake. Sometimes there's a mistake calculation for the overtime or maybe a promotion. Okay, wrong grade was given, so the employer can deduct. Okay, then indemnity due to the employer under Section 13. I think Section 13 you have not studied yet. No? Section 13 is where if you want to resign, you must give notice. Okay, if you do not give proper notice, okay, 1 month notice is equivalent, okay, to 1 month salary. Okay, so if you want to resign 24 hours, you must give to your employer 4 weeks notice. And let's say, so 4 weeks notice is 1 month salary. So the salary will not be paid. So you have to pay to the employer the amount that's the indemnity, what we call indemnity. Okay. Maybe other advances under Section 22 where the employer already given you loan to buy a house, car or anything, or any deduction under the written law like EPF, SOCSO, income tax, the employer can deduct, okay, from the employer's employee's salary. Okay, so the employee also can ask the employer to deduct, but he must give consent in writing. So deduction by employer at the request of the employee in writing. That means the employee asks the employer to deduct where he will sign a form. This is for special cases like any subscription fees or entrance fees, installment loan or anything to do with trade union, cooperative, anything. Okay, that means the when the salary goes before the salary bank into the account of the employer deduct and pay to the third party. Okay, or the employer give opportunity to the employee to buy the company's share. Also can the employer can deduct the employee's salary. Okay, so the amount, maximum amount, okay, the employer can deduct, okay, is not to exceed 50%. Okay, must not exceed 50% of the employee's salary unless the amount to be deducted includes payment of housing loan. So if it's including housing loan, okay, it can exceed 50%. That means it can be 50%, 60% because everything is paid. Okay, so house, you don't have to pay the rental, so you got maybe 50% or 40%, 45% or 40% for your what you call, for your food and other expenses. Okay, so it cannot exceed 50% unless it include housing loan. Okay, so if deduction is to increase, okay, it can increase, the most is 75%, but the employer must get the permission of the Director General. Okay, so you can see, so if the employer want to deduct salary, okay, there's a limit there. Okay, so let's say the employer provide house to the employee. Okay, so it can exceed 50%, 50%, but cannot here exceed 75, because for 75 you have to get the permission of the Director General. Okay, so where salary must be paid, sorry, why not why, where salary, is it where, okay, how salary should be paid. Okay, this is the system that we call a trust system, where the wages should be paid through bank. Okay, so you want to know where your employer pay the salary is, he will pay to the bank. So you must give the bank account to your employer. Okay, and you can also ask him to pay in cash or in check. Okay, and if you want to withdraw any of this method through bank or check or cash, you must give a notice to your employer. But nowadays, I think most of the employer pay through bank. Those days when I was working, I get my pay through check. Okay, but now it is through bank. Most employee get their money through. I mean, they have to get the money through a bank. That means they have to go to the bank, or they can do it online to get their salary. Okay, where wages cannot be paid. Okay, so there are few places where salary cannot be paid. This is at the travels. That means if in Bahasa Malaysia we can say that is a kedai arak. Okay, amusement place is like tempat hiburan, maybe at, you can say like Genting Highland or like that. Okay, at shops or stores, except if the employee are employed at a particular place. This place like at a shop that sells liquor, or amusement place like Genting Highland, or shops at mall. Okay, if you're employed at a particular place, it's okay. If not, salary you cannot pay at these places. Like those days, I know when my father get the wages, and the wages can be paid at the shop or at the office itself, where they are paid in cash. Okay, so these are the places like you cannot pay the salary at the store, let's say at the mini market. Okay, because the money can be spent one day, or amusement place, or the place where they sell liquor, because the salary of 1 month can be spent off within one day. Okay, so there are restriction where salary cannot be paid. Okay, and in case your employer, okay, you got some problem, okay, and his property will be sold on application of secured creditor. That means what do you call, pemutang yang terjamin. Okay, so the court, okay, shall not authorize the payment of the proceed. Okay, that means from the sale to the secured creditor unless the salary has been paid first. Okay, so the provision is to protect the employee's salary. That means if, let's say, the employer is facing financial problem, okay, so the salary should be paid first, rather than the what do you call, the debt of the employer. Okay, so in the Companies Act, there's also a provision on this matter. Okay, so the wages is in priority. Okay, menjadi keutamaan. Okay, in case the employer's property has to be so. Okay. Then here the definition of wages include termination or layoff benefit, annual leave benefit, sick leave, public holiday, and maternity allowances. Okay, so sometimes the employer is facing some financial problem. There's one company wants to take action, legal action, and he want to sell the property of the employer. Okay, so the employee's salary come um, um, should be given priority. Yeah? So what happen if the employer fail to pay salary? Okay, so any employer who fail to pay the salary, okay, actually commit a breach of contract. Okay, and is against Section 15, subsection 1 of the Employment Act. So the employee can launch complaint at the Labour Department, and he also can file another action if he wants, okay, for constructive dismissal. Okay, so constructive dismissal we'll be learning later. Okay, and here for the complaint at the Labour Department, okay, employees earning up to 5,000 can make the complaint. Okay, it's not for those who are earning up to 2,000, but now for any complaint at the Labour Department, it's increased to 5,000. Okay, so any question regarding wages? So many slides on wages. So do you have any question?
So far, no, madam.
Okay, so it's easy, a bit easy because the provisions are from the Employment Act, and you must have the Employment Act with you. Okay, I'm not sure how many students photostat or you have original copy of the Employment Act. Do you have the Employment Act with you all? Students?
Mine is a download file from online.
Okay, so it's some student. I mean, if you're very smart in using, and that means you can quickly open the soft copy and refer. But sometimes the student need the hard copy. Depends. Which way you like. Okay, you can have the hard copy, or you can also have the soft copy. That means you save in your file. Okay, like the notes. So you can refer during the exam or whenever you need. Okay, so now we refer to bonus. Okay, so everyone knows that bonus is additional to the wages, so it's up to the employer to give bonus or not. So we got old case because most of the notes are from Danson Ajurai textbook. So but Danson Ajurai textbook is very interesting because you can see how an author writes the textbook where he take the quotation, the important quotation from the cases, and he also explain in the text according to the topics. Okay, so if you want to improve your English or you want to have more knowledge on the employment law, you can also read Danson Ajurai textbook. Okay, it's quite difficult now to get from the library, but I'm not sure whether you can get it online from your friends or not. Okay, so bonus according to Malayan Agriculture Producers Association, bonus is gratuity to the employee beyond their wage. That means extra to their wage. Okay, it is incentive given to employees. So in this case, the court says that we will therefore order the bonus to be paid to the employees at the discretion of the employer. Okay, so at the discretion means budi bicara. So the employee will only get the bonus. Okay, when the employer decide. Okay, and the amount depends on the employer. Okay, unless you got personal contract. In your contract of employment, okay, it's stated that you will be paid bonus every year. Okay, then you should be paid the bonus. Okay, so we got another case here where the court says that bonus can be contractual or discretionary bonus. Okay, it is art printing work Sdn Bhd, okay, where the court says that if bonus has not been made contractual, that means if it is not stated in the contract of employment or maybe collective agreement, okay, or has not become implied in the contract of employment, then the court will not make it contractual. Okay, so how it can be implied term? Implied means I mentioned the sirat. So implied is where, let's say, the employer pays bonus every year. Okay, every year, then maybe it's already 10 years. Let's say maybe Farah gets bonus from his employer. Okay, so now, okay, because of COVID, okay, the employer says that he does not want to pay. Okay, so it becomes an implied term. Okay, so since there is a COVID, so the matter have to be decided by the court. Okay, whether the employer should pay or not. Okay, but normally bonus is paid at the discretion, so the court will look into the matter. Maybe if the employer do not get enough profit, because bonus is paid when there's a profit. Okay, so the court will decide on this. Okay, now we look at the working hours. Okay, so how long an employee should be asked to work, okay, or should be required to work under contract of service. Okay, so any experience from the students working, maybe during semester break or maybe after your SPM, okay, how many hours do you work in one day? Any student got the experience of working?
8 hours.
Basically 8 hours.
8 hours, okay. So 8 hours Nurul says, and I got few who says that got experience 8 hours. Most of them 8 hours, 7 hours. Okay, so we see how the 8 hours should be. Okay, so here section 60A, but you know that employment act is for those who are earning 2,000 and below. Okay, and your contract is contract of employment should have the employment act should contain minimum provision. Okay, it should not have minimum provision than the employment act. If I confuse you. Okay, so if you ask to work 9 hours, so it will be against the employment act. Okay, but here we will see how the section 60A give few ways an employer can ask an employee to work. Okay, so first is that you can see here, employee cannot be required to work more than 5 consecutive hours without a break of at least 30 minutes. Okay, that means for 5 hours straight, you cannot be asked to work. You must be given at least 30 minutes. Okay, so if you start work at 8, 9, 10, 11, 12, 1. Before 1, you should be given rest, or you can straight away stop for lunch at 12:30. So it will be 4 hours and 30 minutes. So it will not be against this provision A. B is that you cannot be asked to work 8 hours in one day. So the maximum working hours is 8 hours a day. Okay. Another provision say that you cannot work more than 10 hours in one day. So for these 10 hours, you should be given 2 hours of break. 2 hours, because if you look at the definition or interpretation in the Employment Act, what is meant by a spread over of 10 hours, it means that you should be given 2 hours of leisure or break. Okay, and in total, whatever way you use the A, B, C, D, you should not be asked to work more than 48 hours in 1 week. Okay, so your employer can ask you to work 7 hours, 8 hours, but it cannot be more than 8 hours, cannot be 9 hours. Okay, but if he wants you to work 9 hours or 10 hours, he must make sure that he give you 2 hours of break. Okay. So any question regarding the working hours? Yes. If you are working like 8 hours, a consecutive 8 hours, sometimes you need to carry your work continual. Attendance is required. So you must be given 45 minutes of meal break. Meal break, that means heavy meal break. It's not like break, meal break, during which the employee shall have the opportunity to have meal. Okay. So sometimes you should you work for 8 hours, so continuous. So in between, you must get 45 minutes of meal break. Okay. So any question regarding the working hours? No. You understand? Okay. So the employer have few choice. Okay. How to arrange the employee to work. Normally, in Malaysia, we work at 8 o'clock. At the government department, if it is a private sector, 9 o'clock. So 9 means you start at 10, 10, 11, 12, 12, 1, 2, 3, 4, 5. 5 is already 8 hours. So 8 hours work means you give 45 minutes break. Or if you want to make going back at 5:30 also can. Okay, because it can fall under 10 hours, but you must give more rest. Okay. But in total, you cannot ask an employee to work 48 hours in 1 week. Okay. And where you ask an employee to work less than 8 hours in certain day, okay, and you want to increase 8 hours, you can do it. Okay, but no employee should work more than 9 hours a day. So you can ask them to work less than 8 hours, and it must be less than 9 hours. That means you I sometimes ask them to work more hours, sometimes less hours. You can do it, you can arrange, but total cannot be 48 hours in 1 week. Okay. If you want any permission, special permission, you ask the permission of the Director General. Okay. Okay, so we have seen the working hours till now. In many ways, an employer can arrange. Okay. But there are cases where the employee are required to work more than their working hours. That means 8 hours, 10 hours like that. More than 8 hours. So the extra hours, let's say the employee's working hours is 8 hours. If the employee is asked to work, let's say 11 hours, so the 3 hours is actually overtime. We call that overtime. Okay, so it can where the employee can work overtime under this situation, where there is any accident, where the employee have to work have to do more work. Okay, then because there's essential work to the life of community, or essential to the defense or security of nation, urgent work to the machine. Let's say the machine get damaged, and the employee, the technician have to work 4 hours overtime. Can okay, or there's any interruption that is unforeseeable, okay, or anything to do with essential services, okay, like if you are working at a hospital or private hospital, you can be asked to work more than the working hours, because it falls under essential services. Okay. Okay, so if the employer already fixed the working hours, can he change? Okay, so there's a case for that also. Okay, so Sun Mix Concrete Berhad and non-metallic mineral products manufacturing employees. So it's the employer's prerogative to fix and alter the working hours. Okay, but limited to judicially defined standard of reasonableness, and must take into account the customary practice in the place of work. Okay, so the employer want to change working hours, so he must see the surroundings. okay, and also must be reasonable. Okay, so let's say the company A working hours is 8 to 6. Okay, suddenly few companies, because if you have like industry, all the industry have one area like or we call it zone for industry. Suddenly company A say that they want to change the working hours. Let's say they want to start at 10 and then they want to finish at maybe 7 o'clock. Okay, so it's like unreasonable. Okay, so the employer must do it with some I mean take into account customary practice and also must be reasonable. And another case here no Searcham Berhad says that a change in working hours is subject to consultation of the employer with the union because working hours affect the welfare of the employees. Okay, so it's not easy to change working hours. Okay, you have to get the consent of the employees or trade union. Okay, so that's about working hours. So do you have any question? It's very easy. So you refer to the Employment Act to know what are the working hours. Okay. So then now you see the employer can ask an employee to do overtime. Okay. So for overtime, there is some restriction. You cannot ask an employee to do overtime more than 12 hours per day. Okay. Um, sorry, including working hours. That means the maximum can be only 4 hours because an employee shall not work overtime more than 12 hours per day inclusive of overtime. That means the maximum overtime one day is only 4 hours. Or you can also have like 104 hours in 1 month. Okay, so if you are interested, you can look at this regulation. Limitation of overtime work regulation 1980. Okay. So any question on working hours? No, Farah says no.
madam.
No. Okay, thank you. So now we look at public holiday. Okay, so when you're working, you'll be very happy when you get public holiday because you get stress and depends on the company how much work you have to do. Some companies you cannot even move from the chair. You have to be in the office. Okay, you cannot have more than your hours for lunch, like 1 hour straight away. Okay, some companies they're very flexible. You can have like 1 hour plus. It doesn't matter. Okay, so sometimes employees want public holiday, even though they get rest day, they want public holiday to relieve or to release their tension. Okay, so in Malaysia, we got a lot of public holidays until the investors complain that Malaysia have many public holiday. I'm not sure in total how many because from state to state is different. But the Employment Act says that 11 gazetted public holiday. So if your employer give you only 11, okay, you cannot get angry because only 11 is what you call compulsory, okay, under the Employment Act. And 5 is already fixed. That's the National Day, Birthday of Agong, Birthday of the Ruler for the state, Workers' Day, and Malaysia Day. Okay, so another 6 days can be fixed by your employer. So you can give for Hari Raya, for Chinese New Year, for Deepawali, for the Kadazans also. Okay, so for the Christmas, so you can arrange. The employer can arrange. So that's why you can see some companies do not give small or factories lah we can say do not give public holiday during Chinese New Year maybe or maybe Hari Raya because they are not under the law they are not what you call forced to give public holiday for the festival day. Okay, so the employer can choose if you want more for the Chinese New Year you can have more days. Okay, or you can also give extra days. Okay, so public holiday is only 11 days under the Employment Act. Okay, so the 6 days, the remaining 6 days, the employer can choose and inform the employee. Okay, but if the public holiday falls on a rest day, let's say, I'm not sure, Saturday or maybe Friday or Sunday, according to your company, the following day will be a holiday. Okay, let's say in Kedah, I think if it is on Friday, okay, then Sunday will be a holiday because Sunday is a working day for us. So we got extra days. So this is to say that you will be given extra days as a public holiday for the public holiday. Okay. Beside 11, I forgot to amend. If any of the 11 public holiday falls during sick leave, annual leave or period of temporary disablement under the Workmen Compensation, WCA is Workmen Compensation, and Employee Social Security Act, another day should be substituted. Okay, let's say you fall sick on if you fall sick on public holiday or annual leave or temporary disablement under Workmen Compensation or so, another day should be substituted. Okay, so, but I don't think so.
Madam,
The employer will give you. Yeah,
what is WCA?
Workmen Compensation Act. Workmen.
Okay, madam.
Uh-huh. This Workmen Compensation Act is something that we study towards end of the syllabus. Okay. So this is 11. 11 public holiday. So if you got MC and it is Hari Raya, another day should be substituted. Do you think your employer will give you? Do you think your employer will give you? If you are sick on your sick during Deepavali or sick during Chinese New Year or your annual leave, your employer will give you another day? I don't think so. Okay, but the law says that you are entitled. Okay, thank you, Diana, for your reply. Okay, so another thing is that if under Section 60, if an employee is absent without excuse or permission on the day preceding or the day after the public holiday, he's not entitled to any wages on the day that he was absent. This is absent without excuse. Okay, but employer would not allow. If you want to take leave, you must make sure that you apply for the leave and the leave is approved. But the provision under the Employment Act is that because the Employment Act is where if you are unable to attend work also, they give you like chance. If it is more than 2 days, then only the employer can dismiss you. Okay, you must try to contact if there's any thing that make you unable to reach your employer. The excuse is accepted. Okay, so maybe because of that, because it's for those who are earning below 2,000. Okay, sometimes they don't have the facility, and this act was made in 1955. We do not have WhatsApp at that time, or maybe email where we can contact the employer. Okay, so if you are absent without excuse, one day before, let's say 1 day before Hari Raya and 1 day after Hari Raya, so you got 3 days, and this is what normally we do when there's a public holiday. We want to take the day before or day after the public holiday so that we get more days to rest. Okay, so according to the law, if you do not inform your employer and you proceed to absent on the day before or after the public holiday, you are not entitled to any salary on the day that you are absent. Okay, you cannot be dismissed, only you are not entitled for the salary. Okay, so we have gone through public holiday, now annual leave. So annual leave is where cuti tahunan, where you are first time given by the employer after 12 months service. Okay, after working 1 year, then only you are entitled to get your annual leave. Annual is the same. That means annual, yearly. Okay. So how many days you are entitled according to the Employment Act? Not so much, not so many days. If you work less than 2 years, then 8 days for each year. Okay. So this is something extra, extra to your rest day, extra to the public holiday. You got annual leave. Okay. If you work 2 to 5 years, then 12 days, and if you work more than 5 years, it will be 16 days. Okay. That means it will be extra lah. Maybe you got rest day every week, 2 days, then public holiday, okay, 11 days plus 16 days, so you got about 27 days in 1 year, okay, for either to go for holiday or to rest, okay. But now companies have more than this, like 10 days or 15 days or 20 days. Okay, this is very minimum. Okay. Okay, so annual leave. Okay. Also, there's a condition. Okay. Where the employee is granted leave of absence without pay. Okay, by his employer during any 12 months, and the the period of absence exceed in aggregate 30 days. Okay, so the period of absence shall be disregarded for the purpose of computing his length of service. Because you want to know your leave, you have to look how many years you have served the employer. Okay, so if the employer give you leave without pay, so that should not be taken into account for the length of service. Okay, so annual leave every year you get, so you must take the annual leave before end of the year, or sometimes it is brought forward to the next year, but you must complete within 1 month, maybe January. Okay, so if an employee is absent for 10% of the working days without permission, is also not entitled to any annual leave on that year. This is not punishment if your attendance is not very good. Okay, you are absent 10%. Your employer can say that I will not give you any annual leave for that year. Okay, so annual leave should be taken. If not, it would be forfeited. That means you will not get your annual leave anymore. You cannot bring forward. Okay, so you must look at your company, what your company says on this matter. That most of the companies say that it can be brought forward, but they limit the days, maybe 5 days, 10 days, because if not, at the end you got so many annual leave. Okay. Okay, let's say if the employer asks you not to take annual leave because he got so many work for you, and he said that you don't take the annual leave, I'll pay you money. Okay, that can be done. So employee shall be entitled for payment in lieu of such annual leave. Okay, if he been asked by his employer. Okay, then if an employee been dismissed under section 60E, he is not entitled to any payment for the annual leave which is entitled and has not been taken. He has not taken yet. That means dismissed for misconduct. That means he have, let's say, any misconduct, is stole the property of the employer, and the employer found him guilty, so he's not entitled to any payment for the annual leave that he has not taken. Okay, any questions so far? This.
Madam,
Yes.
just now you said that if the employer can pay some money for the employee to revoke his annual leave, right?
Mm-hmm.
Okay.
Because it depends on the company. Said okay, towards the end, suddenly they got a lot of maybe what do you call products to deliver. Okay, so they need supervisor, or maybe they need many staff to be there. Okay, they can make arrangement with the employee so that the employee will not, because normally annual leave we'll wait until end of the year. We normally do that because we got no time. Or sometimes we got enough with the rest day and also public holiday. Okay, so when it comes to end of the year, we think, oh, we should go for holiday, so we can take our annual leave. So at that time, maybe your employer says that, okay, you cannot take your annual leave now because we got a lot of things to be settled. Okay, so the employer said, okay, I'll give you money. That means replacement of the annual leave that you have not taken with money. Okay, so if the employee agrees, then it's okay. It can be arranged under the law. Okay, so nothing wrong with that. Okay.
Okay, understood, madam.
Okay, welcome. Okay, now we look at sick leave. Okay, section 67. Okay, so sick leave also employee entitled. So employee actually getting so many leave, so many what you call leaves, or maybe rest. But it depends. If you're really sick, it's okay. You go to the doctor. Okay, and section 60 have says that you must be examined. Okay, an employee shall, after the examination, at the expenses of the employer. So the employer must pay for the bill, medical bill. Okay, and then the doctor must be appointed by the employer. Okay, so there's two things here. The employee shall, after the examination, at the expenses. So that means the employee will pay for the expenses, medical bill, sometimes for the, here expenses is not actually defined. What is the expenses? Is it for the medical bill, or is it for the whatever medicine that been supplied by the doctor? But it depends. Okay, on the employer. Normally they will pay both for the doctor and for the medicine. Okay, so you can go to doctor appointed by the employer, or if there's no doctor, you can go to other doctor. Okay. So there's a condition, okay, depending on the nature or circumstances of the illness, how bad is your illness, okay, the doctor then been appointed cannot be obtained within reasonable time or distance. Then only you can go to another doctor, which is not normally we call panel doctor. Okay, so if you're sick, okay, and you can go to your doctor appointed by your employer or other doctor, depending on the circumstances, okay. Then if the doctor says that you are sick, then you are entitled to have sick leave, which we call MC, medical certificate. The sick leave will be given according to the year of service. Okay, so the employer can give you sick leave. If you serve the employer less than 2 years, 14 days sick leave. If you serve the employer more than 2 years, up to 5 years, 18 days sick leave. And if you serve more than 5 years, 22 days of sick leave. Okay, so this is where you must be honest. If you're really sick, you go to the doctor. Okay, or if you pretend, sometimes the doctor, that's why they have the panel doctor. Okay, so the panel doctor also must be honest. Okay, he cannot simply give you sick leave. Okay, so this is the employee's entitlement for sick leave. And if you've been hospitalized, okay, under section, you read both of the section here, okay, because it's quite long. I simplify here both of the section 60F1B, B, and also 2B. Okay, so if you've been hospitalized 60 days each year, that means you are awarded. Okay, if you are awarded at the medical center, I think 60 days. I don't know, your employer would pay you how many thousand for this. Okay, so if it's a general hospital, it's okay. 60 days. I think no one want to stay at the hospital for 60 days. It's 2 months. Okay, but the employer can give, sick leave 60 days. Okay, and an employee is deemed to be absent if his sick leave is not certified. That's why you must go to the panel doctor. And if it is certified, you got your MC, you must inform your employer within 48 hours. So you don't take the MC if the MC is 3 days. You don't keep the MC and you go um, on the fourth day and give the HR officer say this is my MC. So under the law, you are considered absent, and if you are absent more than 2 days, okay, you can be dismissed. So, any question on sick leave? I see no videos here. Everybody sleeping or listening to me.
Listening, madam.
Listening, okay, but you don't show your face. Okay,
No, madam, because opening camera, the internet line will become very lag.
I see. Okay, never mind. But you always let ask questions, so I know you are listening, and the others are also responding. And thank you in the chat. Okay. Jia Yi saying that she's listening. Okay, so we got one case actually. It's a old case, so that's why if you read new cases, okay, you can share the case even in the examination, but make sure you put the citation. A citation is where you put the year of the case. Let's say this case, Casbury, Bravery, what you call it? It's plot here, okay? I think Berhad, and National Union of Drink Manufacturing Industry. So the citation will be here, CLJ, MLJ, in bracket 2014, like that. And then by the side, there will be a number 2 or 3, okay, or without a number, that is the volume. And at the end, there will be the page number, okay? So you can put, if you have the case or you already update the notes, some students are very um, they are very, uh, they're very hardworking. They modify my notes and try to get new cases and they put at the side. Okay, and that's why sometimes during the exam we can give up to like A plus where the student's answer is very perfect. Okay, so if you got time, you look for new cases. So in this case, the court found the employee were not entitled to paid sick leave, okay, as they have been certified ill by a doctor who has not been appointed by the company, whereas the workers do not face any medical emergency. Okay, so there's no because you do not fulfill the what you call the circumstances under section 60F, so you cannot go to a doctor not appointed. That means doctor who is not a panel, so your MC is not valid. So make sure that you go to the doctor who is appointed by your employer. Okay, and then because your length of service is important for the number of days that you are eligible for your sick leave. Like in this case, Kelang Port Management Syndrome Berhad versus Karupia, his sick leave was so many days. I'm not sure for the past 1 years his sick leave is very there's so many days. It's more than what been given by the Law Employment Act. So the employer warned him, but he does not care, and at last he was dismissed. So the court says that his dismissal was fair. Okay, but what is important is that the employer must give in the warning in writing. If not, there will be no proof. Okay, you have to warn your employee if his sick leave is more. Because sometimes we got problem employees at work. Okay, where who like to take uh, sick leave, cheat to get sick leave or force sick leave. Okay, so the employer must be very careful and he must give that letter in writing. Okay, so under section 60F, an employee would not be entitled to any sick leave during maternity leave, because maternity leave is already staying at home, so you are not entitled for any sick leave or any period where you will get the compensation for disablement under SOCSO or workman compensation, because you will be staying at home where you don't have to go for work because you are given compensation for disablement, so you cannot claim extra sick leave. Okay. Okay, so hopefully we can finish in today's class, terms and condition. Okay, so rest day. Okay, so another day that you can rest is on the rest day. Okay, so rest day is where the employee have the duty to prepare a roster to inform the employee the days appointed to be his rest day in that month, and the roster must be displayed. Okay, but normally everybody knows that when you join the company, you will know when is your rest day. So because now rest day in Malaysia is fixed according to the state. Unless you're working in a factory, they might have a different day in a week for rest day. Because rest day is not necessary, it must fall on Friday, Saturday, Sunday. It can be Monday, it can be Tuesday or any day. Okay, remember that. Okay, so don't get surprised when your employer suddenly give you rest day on Monday. Okay. So the employee is entitled for the whole day, no half rest day. Those days we got half day as rest day. I remember Saturday was like half day, you got half day rest day. And Kedah, I think Thursday was like a half day rest day. Those days that when I was working, 90s, in 90s in private sector. Okay, you got Saturday and Thursday as rest day. Okay, so where the employee has been allowed more than 2 rest days. Sometimes the employer give 2 days as a rest day. Even now, government employee and private sector employees also getting 2 days as a rest day. But some companies still give 1 day, like Friday and Saturday or Saturday and Sunday. Okay, and sometimes you go Saturday as a half day and then Sunday full rest day also can be, because the law only says that you are entitled for 1 rest day. But if the employer give you more than 1, is okay. Okay, and the last day shall be the official rest day, like Friday and Saturday. So Saturday will be your official rest day. Okay. Then during rest day, you can also be required to work, but overtime must be paid. Same condition under Section 60A, when you can ask to do your overtime under the circumstances, Section 60A too. Okay, I don't want to repeat this. Okay. Only that if you are not sure what is essential services, refer to Industrial Relation Act, schedule. Schedule is at the end of the act. All schedule in the act will be at the end. So you look at essential services, any services specified in schedule. Okay, what is essential service? I think now essential service is coming like common. Everybody knows what is essential service. What is essential service now that you know?
Like the water services.
For the services now, hospital also essential services, perkhidmatan perlu. Okay, you know, if you're working at the essential services, you can be asked to do overtime. Okay, so can see the list, one long list for essential service, banking, what you call bomba, prison, so many. Okay, that is essential services. Okay, so this is the calculation of OT. I don't want to discuss this, okay, because normally the HR department will fix the calculation. And we got also case if the employee asked to do work on rest day, okay, he must give overtime. The rest day cannot be substituted. Okay, but you want the employee to do, suddenly there's a lot of work to do on let's say Sunday, okay, and you say, okay, everybody must come to work on Sunday. Your rest day on Sunday will be substituted to maybe Monday. You cannot do that. Okay, if the employee comes on Sunday, you have to pay double, okay, for the working hours. Okay, so you must pay extra. You cannot replace. If you replace that, the employee will be losing in form of monetary. You get less pay. Okay, now we look at maternity protection. Okay, so maternity protection is where female employee is entitled to get maternity leave for 60 days and also maternity allowances. That means you get leave for 60 days and you get allowances. Your allowances is actually the 2 months pay that you get. Okay, so employee can start maternity leave as early as 30 days before the confinement. They don't have to wait until they deliver, but it can start as early as 30 days before the confinement. Okay, and there's a condition here under section 37(2)(a). You must work with the same employer, okay, at least 90 days during the 9 months. Sometimes if you're very ill that you cannot go to work, so the law is very lenient here. You work 90 days is enough because normally only after 9 months you will deliver baby. So if you work 90 days is enough, okay, before the confinement. And and also you have employed by the employer at least 4 months before the confinement. That means before the delivery, okay, you are pregnant. Before the before you been employed by the employer, you already pregnant. It doesn't matter. Okay, what is important is that at least 4 months you must work with the employer. Okay, before the confinement, then you are entitled to get 2 months leave, and also 2 months is 60 days. 60 days leave, and also the allowances for 2 months. Okay, so this is where to protect the female employee. If you're pregnant, still can be employed. Okay, to avoid discrimination.